Protecting your practice is not optional. It's essential. Today, we're diving into the legal landmines every ortho needs to understand, from contracts and HIPAA to marketing mishaps and patient dismissals. Our guest today is Trey Lawrence, CEO and former general counsel of the AAO. You may know him on Instagram at the Orth Attorney. That's Orth Attorney. This is one episode you want to take notes on, so stay tuned. Our Golden Age of Orthodontics podcast sponsors make it possible for us to bring you new episodes. Cale Owen is revolutionizing orthodontics by turning the chaos of conventional braces into custom control. Their custom digital solution helps you achieve consistent results while saving on average over 7 appointments per patient. It's custom done right, so you can focus on delivering amazing smiles. Find out how Cale Owen can modernize your practice. Book a demo today and get $250 off when you mention People in Practice to your representative. Created by an orthodontist, Grin is redefining remote monitoring with a cost-effective solution that boosts practice efficiency while delivering personalized care for each patient. Grin provides you with dedicated assistance, enabling you to focus on providing exceptional care, all while saving valuable time for you and your patients. New customers can save up to 35% on their starter package. Transform your practice. Better care begins with Grin. To find out more about our podcast sponsors, visit pplpractice.com/partners.
The future of orthodontics is evolving and changing every day. But although the way to achieve practice growth has changed, there's never been a better time to be an orthodontist. Let's get into the minds of industry leaders, forward-thinking orthodontists, and technology insiders to learn how they see the future of the orthodontic specialty. How will digital orthodontics, artificial intelligence, clear aligner therapy, remote monitoring, in-house printing, and other innovations change the way you practice? Join your hosts, Dr. Leon Klempner and Amy Epstein, each month as they bring you insights, tips, and guest interviews focused on helping you capitalize on the opportunities for practice growth. And now, welcome to the Golden Age of Orthodontics with the co-founders of People in Practice, Dr. Leon Klempner and Amy Epstein.
Welcome to the Golden Age of Orthodontics. I'm Leon Klempner, a retired proud board-certified orthodontist, director of orthodontics at Mount Sinai Hospital here in New York, part-time faculty at Harvard, and the proud CEO of the best marketing company in the world, People in Practice. And today, as usual, I'm joined by my daughter and my partner, Amy, and I must say that I feel really blessed to be working with my daughter. We have a lot of clients that work with us that are also family, kids working with their dads, brothers, sisters, legacy practices. So you guys all know what it means. For those that don't have that privilege, sorry, but it's great. So Amy, how you doing today?
I'm doing well. We're fresh off the AAO, so we heard a lot of those stories and met a lot of parent-child, ortho practices, and I was telling the story to somebody that we met, I think. But I have 2 sisters, and you tried to pitch being an orthodontist like over and over. Almost caught one of us, almost. And it was a nice offer, coming to the practice, to thriving locations, and best profession in the world. You always say that. So
yeah, but the only thing that got in the way was organic chemistry.
I know. Well, it's an ortho killer. And it's just like, it's gonna take you right out of the game if you can't do that.
Gone.
I know. Yeah, no, I wasn't about to do that. I mean, it takes a special person. You have to have a lot of skills in a lot of different areas, and the people person and the kid person, and then the technical skills, and you got to be at the top of your dental school class. Oh, you have to go to dental school too, by the way. So it's a lot. It's a lot. Anyway, here I am. We're working together now. We circled back after your 38, 40-year career as an orthodontist, and we're working together. So you did it. You caught one of us, just in a different way.
No,
anyway,
I think you caught me. You caught me.
I know an opportunity when I see one.
Okay.
Yes, I'm Amy Epstein. I am the first daughter of Dr. Leon Klempner and also a career marketer. Spent some time outside of the industry of orthodontics and spent about 15 years inside the industry of orthodontics, bringing some of the tenets of marketing over to the industry of orthodontics because marketing, the framework of marketing, although changing, a lot of the core pillars of marketing are the same no matter what kind of business that you're in. They're business skills. So anyway, thrilled to be in ortho. I recognize it as the best profession in the world as well. So I talked about the AAO, fresh off the AAO annual meeting. Here we are. And today's guest is Trey Lawrence. We're super honored to have him here only a couple of days later. Trey, he's the CEO of the AAO, and he has had a long and distinguished career in law and advocacy. He's been on the show before, and we've asked him all the questions, and we're going to ask him some different ones again because we know that they're always top of mind. He's been a pivotal figure in guiding orthodontists through complex legal and regulatory landscapes. Prior to this being the CEO, which is just this year, he was the general counsel of the AAO, leading advocacy efforts on both state and federal levels. Trey holds a degree from Missouri State University, Washington University in St. Louis, and Harvard University. And as my dad mentioned, he's also known to many as the Orth Attorney on Instagram. So, and that, I think is a great way it illustrates Trey's commitment to making the legal information that he has both accessible but also actionable for orthodontists. And so we're excited to talk about his insights and the evolving challenges that we're facing today. Trey, thank you for being here.
Absolutely. Thank you all. I hope I live up to all of that now. We'll see what we deliver in the next 20 minutes.
You're not new to our podcast, and we know you do. So you don't have anything to worry about. But I want to say one thing before we talk about all the questions that we have for you. I was recently on your LinkedIn and I saw a post that you shared about being an introvert and being in this profession, being an introvert. And so as a fellow introvert, I wanted to say I felt very seen by that. I gave it the little clap, and a lot of people did too. One of the things, for those that didn't see Trey's post, the idea of sitting back and listening first, which is one of the core traits of introverts. It's like not necessarily to have the loudest voice, but to stop and listen first and then react after you've been able to take in all the information that's being shared in a conversation. And it can sometimes, I've gotten this feedback before in my professional career in public relations as being like a little aloof and by others that are more extroverted. And if you spend enough time with introverts like us, you realize that we're really paying attention to all the details. And so I wanted to say thank you for that. And also I wanted to talk about how that character trait is shaping you as a CEO now, or if it's influencing your approach.
Yeah, no, absolutely. It influences everything you do. And I'll start with, you are not alone in feeling heard by that. So that post did better than, I'm not a huge presence on LinkedIn, but that one certainly got some attention on LinkedIn. So later on, I created a post, and TikTok being my primary intended audience, and that has been by far the most successful thing I've ever posted. 100,000 plus views. And
wow.
But the comments were just amazing, because so many people, like you said, say, I've worked in my job for 10 years and I've been frustrated the entire time. I feel like nobody understands me. And so that's been the big piece of it for me is, first of all, recognizing there neither mindset, an extrovert and introvert, is better or worse than the other. They just have strengths and weaknesses. And you have to start in yourself and lean into the strengths that your own skill set possesses. So for me, it was that listening piece. And so like how I've played that out as CEO for the AAO, even though I have been at the AAO for almost 6 years before I stepped into the CEO role, I really took the first 6 months to still kind of sit back and listen from a little different perspective. I was hearing from a different group of members than I dealt with mainly in the advocacy part of the world, and hear what they were saying needed to be done, and then start to take action after that. And we've got some things going on, some revamped social media that's coming in particular for AAO that was a result of that listening, as opposed to, because the pressure as the CEO, even someone who's already been at the AAO, is to come in and just launch some revolutionary new thing the first day, the first 100 days in office kind of thing. Mm-hmm. But I fought against that and just really laid back and listened for a while as I started.
Yep.
Well, let me tell you, Trey, I have been, let's see, I graduated in 1977. So I have not missed an AAO meeting since I graduated. And I honestly will tell you, this was the best one. And it for those of you that have stopped coming, you got to start coming back again, because it's a different AAO under this leadership. It was fun. It was informative. It had a whole entirely different vibe.
So we look forward to seeing everyone who's listening here next year at the AAO, because it really was. I've been going for probably 15 years, and it's the best one I've ever been to.
Yep, that's what we want to hear. And again, we've been listening. I know all those who know Dr. Callahan as our president that just finished his term. Many would not maybe summarize him as a listener. I mean, he's got a very outgoing, flamboyant personality, but he's a listener. Mm-hmm. And so we listened to what members were saying about, not so much listening to members about why they aren't coming to meetings in particular, and what they're really looking for in addition to CE. And I'm very excited. We've got several board members coming as the next few presidents that are equal listeners, and we're going to continue to listen and do those things that our members want. And I think you saw that this year.
Mm-hmm. Definitely. Well, let's dive into some of the questions that our listeners have shared with us that they'd love to have us talk with you about. And no surprise that a lot of these are in the legal landscape, risk management arena. First, we wanted to ask you, from your vantage point, the most common legal blind spot for orthodontists today. And that may have changed. This question may have been answered differently last year or the year before. But today, what are your thoughts on the most common legal blind spots?
I still continue to think that it's a combination of primarily HIPAA violations, but some other things all wrapped up into social media, because social media is, it's still relatively new. I mean, the law lags way behind, when something develops. So the law is just now starting, the court cases and the litigation are just now starting to catch up to social media. But I think the other thing that makes it the big area that practices are making mistakes now is because my anecdotal, I don't have numbers to back this up, my anecdotal observation is that the last 3 years or so have really seen kind of a flood of practices that have finally realized, hey, we got to step up our social media game. We've got to get active there. So it's really this huge movement of people who have never really even, they've not been in that arena to begin with, period, much less thought about the legal risks in that arena.
Yeah.
And that's where I continue to see, I always joke, every time I get on Instagram, I see somebody that's breaking a law somewhere among all the practices that I follow.
So tell me, like, an example. What common example of because now everybody's listening. I'm doing this. What am I doing wrong? So what are some, like, one or two just common?
A big category is practices not really realizing the extent to which HIPAA protects patient information. So everybody knows you can't turn loose treatment details, those kind of things. But HHS has been very clear over the last couple of years that just the fact that a patient is treating at your practice is PHI that's protected under HIPAA. So anything that you do disclosing the fact that the patient treated at your practice, unless you have their consent specifically for social media to do it, is a HIPAA violation. So things like I see, like when practices have drawings and they pull out a winner's name and they read the name, and I see them reading the full name. So I'm hoping every time they do that, they've got a signed HIPAA release from that patient or mom or dad, because otherwise they've just disclose the fact that that patient treated there, and that's a HIPAA violation. So, or the, photos that have patients in the background and not really being as hygienic as they need to be about minding who's in the background of, not, oh yeah, we've got a signed release from the patient in the chair who we're getting on this reel, but we didn't think about the 3 others that are walking through in the background behind them. So just any of those things that just show that somebody's in your practice receiving treatment, you've got to have either authorization from them, or you've got to make sure that they're screened from making it into those posts.
Yep, that makes total sense.
Yeah. So Trey, if I'm a listener and I'm listening in on here, I'm saying, okay, there's risks here. I'm not going on social media. I'm not going to do any of that stuff. So what do you say to those listeners that are afraid and nervous about utilizing it and just kind of abandoning it altogether?
Yeah. Well, so the short answer is don't say that. I mean, you have to be on social media. Our AAO data is showing the trend that patients who are first coming to contact with the practice, it's increasing dramatically, is social media and online research being 2 primary ways now. I mean, that's replaced it's almost to the point where it's replaced the friends and family referrals, and only referrals from GPs are still ahead of social media and online research. So you have to be there, I think. So the thing is, then just make sure you know what the legal risks are. So certainly I think working with a reputable, marketing company or practice management team that can help you, working with experts in the area can help you guide you through some of those risks. And then obviously the AAO legal resources, my own social media. And so much of it is not necessarily you have to have the law memorized. It's just be conscious of what the risks are. And that's easier than knowing exactly what the law is. But you have to be exposed to it and read about it or see it. And I think that the combination of working with a really reputable, knowledgeable marketing team for your practice and utilizing AAO legal resources can get you about 90% of the way there.
Mm-hmm.
All right, great. So, we have a lot of topics to cover, so I'm going to be flipping back and forth, kind of rapid fire type of thing. So I work with residents, right? That's what I do. I love teaching. I'm with residents all the time. They're coming out with $500,000 or more in debt. They need a job when they get out. So, and they don't have much background in terms of business or legal. So my question to you is, there's a lot of confusion on a lot of topics. Non-competes come up, as one topic, but, what should new grads or young associates be on high alert for when they're interviewing and reviewing job offers?
There are several things that can sneak up on you. I mean, even something as fundamental as how the contract is structured. I've seen several what are titled independent contractor agreements over the years that you start reading them. And it's very clear that that's an employment relationship, but the hiring entity, it's in their best interest, obviously, to classify somebody as an independent contractor. And so they've titled it that way. And as a resident who's graduating and not familiar with all this, you might easily miss that and just take their word for it that you're an independent contractor. That's a big one. Certainly the non-competes, and what's really challenging about the non-competes is that nobody really knows exactly what the law is right now. The FTC has passed this ban, but like always, it gets tied up in years of litigation and nobody knows what's going to come out on the other end. I suspect that hiring entities are going to be looking at ways, even if that ban goes in place, to still basically do the same thing. And I think the other challenge where I've seen the most trouble lately is in multi-location. So the employer has multiple locations and your interpretation of a non-compete may only be the one specific location that you're working in. And then you go to leave and find out that they're measuring 10 miles out from every practice location that they have. And so those are the kind of things, A, that you might not catch, and B, if you don't have experience in negotiating a contract yourself, then you might not know how to try to fix some of those things before you sign it. So I always advise residents that I know a newly graduating resident is not in a point in their life where they can spend a lot of money on anything, but there are people who will review a contract and do a good job, are credible, very skilled attorneys. and will charge a fee. They know where a resident is at that stage in their career. You know, their goal obviously is to get that resident's business later in their career. So if a resident is in that spot, please contact us at the AAO. We don't have an official endorsed program or anything like that, but we can absolutely give you the names of 2 or 3 attorneys that have worked with many other residents and I've heard good things from. And it's, you know, it's less than 4-digit dollar amount to review those things. And that should be, it's an investment that's well worth it for a resident as opposed to end up in a mess that you spend a lot more than that later trying to get out of.
Yeah. We work with a lot of, residents just coming out and looking to associate or, and so this is good for us to know. So as we talk to our clients, and I'll share it with our growth consultants as they talk to their clients too, that the AAO can be a resource here. So that's good. Very good.
Definitely.
Let's go back to HIPAA for a second and talk about online reviews. And it's something that probably makes it into every podcast we have together because it just keeps coming up. And we handle this in partnership with our clients. So we know how and how not to respond. And but there are a lot of people who may be listening who you will eventually get a negative review. You can't please everybody, and that's just what it is, and that's okay. And most of the time, you'll hear that don't respond to that, or just lay low. But the instinct is to defend oneself when you're being accused of something that you feel is it's misrepresenting what happened, and that's always what happens. It's never really like the honest situation because everybody's perspective is their own perspective, right? So somebody's upset, they write a whole thing. You're like, that's really not the whole story. And you feel like you want to tell your story. So Trey, let's just say you have somebody and they're in that position and they come to you and they're like, I gotta tell my side of the story. What do you advise them? Yeah,
it's funny. There's kind of a chain of instincts that somebody goes through here, and neither one of which am I a big fan of. So instinct number 1 is the defend yourself instinct. So I would say stay away from that because if you're not acutely aware of the risks, so easy to step into a HIPAA violation that you weren't thinking about. And it's especially the case because anytime that you're writing one of these, you're emotionally charged, and that clouds judgment and, clouds the senses to be alert for these things anyway. So I absolutely don't go with that instinct. But then instinct number 2 is to not respond at all, as you just hinted at. And I don't love that one either, because to me, that seems, if you're a prospective patient and you see what sounds like a really bad situation, and then there's just no response. I mean, this is just for businesses generally. This is not unique to orthodontists. Then that doesn't send the optics that you're looking to create either. So that's why I think a highly curated, very careful response. Our AAO recommended response is always, it appears there's been a misunderstanding. Please contact our office to set up a time to discuss. You're not admitting anything factual about the patient, even that they were a patient, but you are responding. But the other big thing is get it offline, because you don't want that thing to turn into a protracted, multi-post discussion online either. And so it's get it offline, even if you've already dealt with that issue with that patient, still get it offline. And that's why we like that response.
Yep. That makes total sense. Yeah. We've seen this go awry before, right? And you don't want this back and forth out there for everyone to read. And
no matter how many times we counsel our clients, our orthodontic practices to consult with us, don't immediately answer. Take a deep breath.
Keep it simple.
Give it a
Here's
day.
What to say.
The emotions and, we're sensitive people, us orthodontists. We take it seriously when, one person doesn't like us and we're keeps us up at night. So that's just
Well,
the
I
way they are.
mean, you're in an industry where most people are really happy with what you're doing for them.
Yeah.
I mean, you come out and your confidence is up, and everybody, you
It
look
doesn't
better
matter,
and you
Amy.
feel
It
good
doesn't matter.
and whatever. Well, I'm just saying, you're used to getting the positive feedback, and then when something shows up that isn't, it's like I can imagine that it's
Let's say I'll treat 1,000 cases and I get a beautiful result. And then I have one that something goes awry. That keeps me up at night.
Yeah,
I know we're like perfectionists. We struggle over a 0.5 millimeter midline deviation at the end of the case. It's just the way we are. So it's hard for us to do what you're asking, but it's critical and important for our listeners to understand that. So let me flip the topic again. And let's talk about malpractice and informed consent. So, I've been around for 38 years. I've taken all the, insurance courses and talked to different clients. So I know that informed consent is almost like the iron that we have to protect ourselves against malpractice. It's got to be solid. But most of the informed consent is, at least in my practice, was filling out the form, maybe asking questions, sometimes not. Sometimes it would be done by, the TC and not me. So give us some guidelines in terms of what you feel would be the best way to manage informed consent in orthodontic practice.
Yeah. So you already, the fundamental underlying truth here, you already hinted at, which is that informed consent, not the signed form itself, the patient giving informed consent is the single most important element in any defense of any malpractice claim, because the vast majority of malpractice claims are either I experienced a risk that I didn't anticipate, or I had a result that I didn't anticipate. And so if you have evidence that the patient understood the risk or understood the treatment outcomes and agreed to treatment, knowing that, then that negates a huge number of those malpractice claims. But the challenge is always that this is not unique to patients. This is just consumers generally. When your legal defense rests on a signed document, the consumer/patient is always going to try to argue, I didn't know what I was signing. So I can't be bound by what's in that document because I didn't know what I was signing. So all the classic scenarios of the credit card agreement that has 10 pages of fine print and no reasonable human could be expected to read and understand all of that. So the key then is you have to design your informed consent process with the patient in a way that removes as much possibility for them to make that argument as possible. So this informed consent topic continues to make me nervous because as we develop, all these really cool new tools for patient intake and filling out documents online before they even come in and all these things that are so helpful in so many ways, I know the temptation is just to slip that informed consent with those. And I think the single best thing to help prevent a patient from claiming they didn't know what they were talking about is still having either actual contact with the doctor or at least being offered contact. I mean, the best practice is always going to be have the doctor actually talking with the patient about what's in the informed consent before they sign. I understand practices have different workflows and many don't regularly have the doctor do that. At the very, very least, give the patient the opportunity. Say, okay, I've explained everything to you. Do you have any questions or would you like to talk to Dr. Smith? If so, I'd be happy to have her step in here before we have you sign this. Something like that. Because I think from what I've seen, the biggest thing that makes patients claim that they didn't know what they were signing is because that's all essentially, everything in an informed consent is essentially treatment information. And if they say, well, no, some staff person gave me all this, but I never even had the chance to talk to the doctor about this before I signed that. That's the single biggest place where I see the challenges to an informed consent coming up.
Mm-hmm. I mean, what if the patient says, like, even if you said, would you like a chance to talk to Dr. Smith? And they say, they didn't say that, right? Because how do you do you say that's just part of our protocol? You can see our protocols here. It includes how do you prove that you offered that opportunity?
Yeah, I think the more evidence that you have to establish that that's just your standard workflow for your practice, then that helps. That certainly, if you have a written document that you've given to staff that says this is our intake workflow or this is our informed consent workflow, that's going to be immensely helpful. Even short of that, just the testimony of staff. If you have your treatment coordinator is regularly the one that walks through the informed consent, and then she or he is able to testify, no, every single time it's just our policy that I would at least offer to the patient to have the doctor come in, and then that matches what your testimony as the doctor is. It's just the more evidence that this is our workflow and we don't deviate from it, that's going to be compelling to a court or a jury.
What about just simply putting a comment in, form consent reviewed, patient given an opportunity to talk to the doctor, had no questions, something like that?
Yeah, that individual entry in an individual's chart is going to be another piece of evidence. I mean, any of these things with evidence, it's always the more the merrier. The more evidence you have, the better. So certainly could be an important piece too.
Okay, great. Okay, so moving on from this negative review situation and then malpractice and whatever. When you see something coming down the pike with a patient or a potential patient where they're either being disruptive, they're not paying, especially in tricky cases, and contentious co-parents, things like that, what's the safest way? Or I guess the first question is, should you dismiss that patient? And if so, what is the safest way to do that?
Yeah. The rule of thumb is that as long as you're not by dismissing the patient, you're not leaving them in a worse situation than when they first came in, then you always do have the option to discontinue. I think the law is probably quite a bit broader than most doctors realize on the instances that you can dismiss a patient. So, something like non-payment, if they're 6 months behind on an account and no hope of catching up, that one's more obvious. But these disruptive patient situations, I think to Dr. Klempner's point earlier, the perfectionist orthodontist doesn't want to, kind of admit failure by dismissing a patient. This situation was so problematic that we had to move on. But in many cases, that's the safest course, is to move on. And two, the other thing I think sometimes the doctor may lose sight of someone is you're under an obligation just not only to protect yourself legally as the doctor, but you also have to protect your staff too. And I know many times those problem patient situations are even worse for the team members than they are for the doctor. And so there is an obligation there as well. So as long as, certainly giving the patient or the parent notice, having a conversation with them and documenting that you talked through the concerns, sending them a letter saying, these are the concerns that have arisen and we would love to continue to treat you, but may have to consider other options if they don't change. Some kind of advance notice like that certainly helps. Obviously, if somebody walks in and is physically threatening staff or something like that, you can dismiss them instantaneously. But to do all of that, if you do all of that and lay the groundwork and then you send the proper documentation afterwards, the letter that includes we're dismissing you for this reason. We will see you in the next 30 days. If you have an emergency, we're happy to provide a copy of records to you, and we can refer you to another provider if you want to continue your treatment somewhere else. Those are the legal elements. If you do all of that, then you're covered legally. So why wouldn't you avoid the additional risk that could come up from trying to power through it and continue to treat that really problematic patient or parent?
Yeah. I think that just talking about the process there, one of the hardest things in that process, I would imagine, is the first thing you mentioned, which is have a conversation first and then follow up. I don't know. I know many orthodontists that don't want to do that, but as a communicator of, at the AAO, I gave a talk on transition communications and how, something's happening at the practice and you want to tell patients as soon as possible, as clearly as possible. They don't want to hear it from somewhere else. Face to face, especially as you're talking to your team about a change, is the best way to do it. And I would imagine that it would go really far to be able to have a face to face and be like, look, we're facing these challenges. These are the things, I just want to make sure that you're aware of them. And, before sending a letter would be a best practice, right? Like that would probably make things go much more smoothly than just receiving a letter in the mail.
Yeah, absolutely. I mean, certainly just on a basic human.
Exactly.
It's just the personal dynamics as opposed to getting something in writing, which is, or same thing goes for trying to raise the concerns first through an email or whatever. Now, exactly how to have that conversation, that's where I will happily defer to the experts like the People in Practice team. As the lawyer, I can only tell you need to have that conversation. Yeah. But I know that there are others like you all that are much better situated to, provide a framework for how to have that conversation.
Yeah, for sure. Well, we do know you have to do it privately for PHI purposes. Yeah. So we know that much.
So Trey, time's flying by, but I can't let you go without talking about my favorite subject, which is AI. I gave a talk at the AAO about how quickly this technology is permeating into the orthodontic profession. So I'm curious, from your perspective, so as AI plays a greater and greater role in orthodontics, in diagnosis, treatment planning, and even in marketing, People in Practice are investigating this area very thoroughly. What legal and ethical questions should orthodontists be thinking about?
Yeah, the AI is like so many other technologies that have come along that offer so much promise from the proper use, but so many risks or challenges from the misuse of it. And the AI in particular, I think, really goes to Dr. Callahan as our president that just wrapped up. He's called this the existential question for dentistry, and it's protecting the sanctity of the doctor-patient relationship by not allowing technology to replace the role that only the doctor can fill. And so that's really the standard by which any of these technologies, I mean, it's the same thing with teledentistry and direct to consumer that hopefully we're starting to see a little bit of subsiding finally there, but it was the same thing where technology was used to replace the doctor in the role that only the doctor can fill. And that's the question for AI. So the challenge is the AI, I think those lines can get a little blurrier. And so this is going to continue to be a conversation that will go on, I'm sure, in the foreseeable future. I will, a little AAO commercial here. The AAO has assembled a task force on the use of AI in orthodontics. It's comprised of educators and researchers, clinicians, and then some of our industry partners as well. And they are nearing completion on a position paper that is the first step in helping to clarify some of that blurry area in when the AI is replacing the doctor. The central thesis of the position paper is just exactly what I said, that the AI should be used as a tool to assist the doctor, but should not be replacing the doctor in the areas that only the doctor, that are solely the doctor's role. And so, but I'm certain that this position paper, once it's finished, like they say about so many things in IT, it will never truly be finished. I think it will be an ongoing process as new particular technologies come out to help define when is this being used properly or when is this replacing the doctor. So, I anticipate probably a year or two from now, we could probably sit and have a whole 30-minute conversation just about specific applications and where that line rests with those applications. We're not quite there yet, but this is something the AAO is acutely aware of and want to be sure that we're on the forefront of helping our members deal with it as much as we can.
Sure.
I'm going to put it on the calendar for 1 year from now.
Okay, deal.
Right after the AAO next year. So, Trey, thank you for being here. Thanks for sharing all of this really valuable information with us, and illuminating where the AAO can be a resource for orthodontists to get really thoughtful well-researched information about these questions that we had. If there are specific questions that we didn't cover today that maybe our audience members would like to address with you, is there a way to reach out to you directly?
Yeah, the easiest way is if you get on the AAO member website, there's a legal resource center. One of the tabs there is a contact the AAO legal team tab. So that you or a team member, as long as they, if you want to have one of your team members submit a question, just fill out your name, your member number, and put the question in, and then an AAO attorney will get back to you by email. So that's one way for me personally. At the Orth Attorney on Instagram, it's going to be the easiest way. So try as I can to post content there, but certainly always happy to respond, through DMs or other outreach by members or anybody in dentistry, honestly, through Instagram.
Mm-hmm. It's great. I mean, you're really accessible. I mentioned it at the top of the show, and you make the information accessible, and you are accessible, which I know is really appreciated by many orthodontists and AAO members. So thank you for that.
Yeah, no, absolutely. Absolutely. That was one of my priorities even well before becoming CEO. And my little secret that I always spill is all that legal information on Instagram. I mean, I'm very happy that that's helpful to AAO members. Really, that was just my little secret in to make more connections with AAO members and just use the legal information as a tool. But the connections are really the most important part.
Mm-hmm. Yep. And for all those that think that introverts don't like to make connections and be connected to people, like you're looking at a couple of them right here. And, we just take a different route to getting there. So Trey, thank you again for being here. I look forward to seeing you again soon. And if not before then, 1 year, same place, same time.
Deal.
Thanks,
all right.
Trey.
Thank you all.
You can subscribe or download other episodes on Apple Podcasts, Spotify, SoundCloud, YouTube, or wherever you get your podcasts. And if you enjoyed it, as always, we'd appreciate it if you would tell a colleague about us. For more information about People in Practice, you can visit our website at pplpractice.com.
Thanks for watching and listening. I'm happy to say that we've reached our 1 millionth download last month for
That's
People in
right.
Practice. So appreciate everybody there. By the way, it's the Orth Attorney. I made this mistake. It's not the Ortho Attorney.
No, it's the Orth Attorney. Orth Attorney.
Orth
Like
Attorney.
orthodontist. Orth Attorney.
Orth Attorney. Okay. If you want to reach me, talk about marketing, talk about AI, talk about risk management, anything that we've talked about here on the podcast, it's leon@pplpractice.com. If you're looking for a deal, our sponsors are offering a deal to our listeners on our partner page. You can go to pplpractice.com. And remember, most important thing, for forward-thinking orthodontists, it has never, ever been a better time to be an orthodontist. We are in the golden age. Take advantage of it. Bye for now.
Thank you for tuning in to the Golden Age of Orthodontics. Subscribe now on Apple Podcasts, Spotify, or visit our website at thegoldenageoforthodontics.com for direct links to both the audio and video versions of this episode.